Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday night. Yes, sir. We had huge storms come through today. There are trees everywhere. Down. All over the place. It is a mess out there trying to navigate the road. But we made it. We're home. Everybody's home and safe right now. I'm just going to pretend. Everybody's home and safe. And nothing happened today. Alright. We got a jailhouse lawyer, guys. He's ready to play. Here we go. Nope, not that one. We're a little early for that.
Were you able to call the Mr. Bramsher case?
Yes, he is next. All right, so I'm going to call 18M101, 26M423, 18M853, 18M676, 19M1056, 26M685.
Damn. Leave some crimes for the rest of us. We want some too.
Just talking. 17T3719, 26M221, 17M2052, 17M2106, and 18M590, People versus William Bramsher.
Anders Erickson for the people.
Nero Jamler, Judge for Mr. Bramsher, who's present on WebEx.
Mr. Bramsher, can you hear me okay?
Your Honor, as a matter of fact, I can aloha.
All right, hold on, Mr. Bramsher. Hang on. I'm going to give you an opportunity to speak, but let me address some stuff first, okay?
Yes, ma'am.
All right. So we were here last week on May 12th, I think. At that time, the court had received the competency eval that was filed on May 8th. The defense had reviewed it and had requested a second competency eval given their disagreement with the findings of the current eval that we have. For the record, that current eval finds that Mr. Bramsher is competent to proceed and does not believe that he has any sort of disability that precludes him from being able to understand the proceedings and being able to proceed. The court set this matter over so that I could review that evaluation in its entirety. Has made a number of requests to include the filing of motions to remove counsel from his case. The court had declined to address that issue until we had the competency eval back and until I could make the requisite findings with regards to competency. I was not comfortable addressing the attorney piece of this with the competency issue unresolved. I have since reviewed that eval and have reviewed it thoroughly. Would note that throughout the eval, the evaluator does recognize some of the concerns that were raised by defense counsel, but goes on to state that despite those concerns, Mr. Bramsher has a very good understanding of the legal process and proceedings. He, aside from some questions, I think generally, which he has also posed to this court about these cases and these specific charges, he understands the process. He understands who the players are, what they do, what their roles are, and basically has some objections to what is taking place. And the evaluator ultimately has said that even though those objections may be grandiose or perhaps even irrational, they do not rise to the level of him experiencing any type of mania.
Delusional should count, though, as not competent if you're delusional.
Or incompetency issues, and ultimately, despite those things, they do believe that he is competent to proceed. So with that, what I'm prepared to do today is adopt the findings of the evaluation, find that Mr. Bramsher is competent to proceed. I will find that he does not have a mental disability or developmental disability that prevents him from having a sufficient ability to consult with a lawyer or to be able to assist in his defense. I will therefore lift the stay on these proceedings I'm not going to grant the request for the second eval, in part because Mr. Bramsher has requested a number of times to have this public defender's office, specifically Mr. Jamindar, removed from his case. And so given now that I have the eval and I can make the findings that I believe he is competent to proceed, I'm going to lift those mental health stays that were issued in each of these cases. With that, Mr. Bramsher, let me just ask you a clarifying question, and I want you to just address this question right now. Is it your request to have Mr. Jamindar removed from your cases?
That is a correct statement, Your Honor, as expressed through a Ferretta waiver expressly.
Okay, so what I'm going to do at this point is I'm going to grant that request. I will remove Mr. Jamindar from representing Mr. Bramsher at this time. Mr. Bramsher, then that leads me to some other questions, which is, are you going to be trying to obtain other counsel? Are you asking for the court to appoint different counsel, or are you asking for advisory counsel?
Your Honor, I am going to expressly waive counsel under the Ferretta waiver. I am going to request advisory counsel, and I'm going to also request supportive services, please, which I believe helps me with some funds for paper, envelopes, and different things so that I can intelligently write the court with motions, etc.
Okay, so let me first address with you.
Oh, I'm losing you. I lost you there, Your Honor. I couldn't hear you.
I'm going to address with you the first point that you brought up, which is the waiver of counsel, okay?
Yes, Your Honor.
I have a series of questions. Some of them are going to seem repetitive, but I'm going to go through them one by one and just have you answer them, all right?
Yes, Your Honor.
All right, do you understand?
I don't know what he's charged with. They just read off 768 different case numbers he has. He has all those case numbers, but they don't say what they are in this hearing.
And that you do have the right to be represented by an attorney throughout these proceedings.
I do.
And do you understand that if you could not afford an attorney, that the court could provide one for you free of charge?
I do.
Do you understand the charges in each of these cases and the maximum penalties that you face?
Your Honor, an explanatory explanation. As I written to you and in my Colorado Supreme Court motion, I have not been given or had access to discovery. So my limited understanding is through the charges that were handwritten and given to me from a deputy here at the jail. And also, I did get a copy of the icon.
That was a yes or no question, sir. Yes or no?
Or register of actions, which includes a detailed list of every case and every charge, but of course does not have police reports nor charging documents. So that is what I have currently. So if allowed to go pro se today, I'm going to motion for discovery, if that makes sense.
Yes, that makes sense. Do you want me to go over the charges and the possible penalties with you?
Your Honor, I will waive that, please. I believe my understanding is firm on that, and so I will waive that, please.
All right, so I'll find that he's waiving further reading and advisement of the charges and the associated consequences for each of his cases. Next, Mr. Bramsher, do you have any official legal training?
Your Honor, I have been called and I have referred to myself as a jailhouse lawyer. In college, I had a double major of psychology and incorrectly listed in the competency report. My second major was speech communications with a public address and rhetoric emphasis. I have spent a lot of time personally researching the law, including here at the jail on the law kiosk or on the tablet. So I believe I have a firm understanding of the Constitution and its amendments, and also the different nuances of the law that would be applicable to this case.
All right, so what I take from that, Mr. Bramsher, is you don't have any official legal training, but you've got some self-taught principles that you have done over the years. Is that fair?
Yes, Your Honor, and I've also represented it myself in court cases, specifically, as I've mentioned, 10CR3690. The charge was retaliation against a judge in Adams County. 3 public defenders quit that case. I was forced to go pro se, and I was found not guilty by a jury of my peers.
That is crazy. And he won that case.
I was in custody for for 12 months on that case. But again, Your Honor, I was found not guilty by a jury of my peers. As I've mentioned, former retired Captain Attila Dennis of the Douglas County Sheriff's Office was a witness on my behalf. So was Julie Riskin of the Colorado Cross Disability
Okay, hang
Coalition.
on, Mr. Bramshire. I'm just going to try to rein you back in a little bit.
Oh, yes, ma'am.
The next question I have for you is, are you under the influence
I was actually listening to that, Judge. I wanted to hear more.
of any drugs, alcohol, or medication that would affect your understanding of these proceedings today?
No, ma'am.
Do you wish to consult with a public defender or other attorney before you make a decision to waive counsel and represent yourself?
No, ma'am.
Do you understand that criminal law is a complicated area and that an attorney trained in this field could be of assistance in preparing and representing your defense?
That's why I asked for advisory counsel. I do understand that, Your Honor.
All right. Do you understand that you have the right to remain silent and that any...
Again, I have to ask about the record. I asked about this last stream. Do these lawyers keep track of their wins and losses? And if he's advisory counsel for this guy, does he get to count that as a win or a loss? Because that's not fair.
Anything you say can be used against you in court.
Your Honor, that's the first time I've been read that statement, and I do understand that. Thank you very much for the advisement.
That's the first time someone ever told you you have the right to remain silent. Anything you say can be used against you. That's the first time you've been read that? Come on. Come on.
Do you request the court to appoint advisory counsel for you at this time?
Your Honor, with the number of cases, I do request advisory counsel because they would be helpful in gaining materials that need to be subpoenaed and or subpoenaing witnesses and just for, as you can imagine, other convenient things. So I would appreciate that, Your Honor.
All right. Do you understand that you have the right to represent yourself, but by doing so, you take a greater risk of not properly presenting your case or cases?
I do understand that is a risk that I'm willing to take, Your Honor.
Do you understand that you have the right to confront the witnesses against you and to cross-examine them?
Your Honor, I have been reviewing today Crawford versus Washington, 2004, and the testimonial and non-testimonial hearsay in the competency
Oh my God, that's what I read to go to sleep last night.
report. I'm well aware of that. Thank you very much, and I do consent and agree.
Do you understand that you have the right to have subpoenas issued to compel the attendance at trial of any witnesses you desire to appear and testify on your behalf?
This I understand, Your Honor.
All right. So with all of that, Mr. Bramshire, what I'm going to do then is appoint advisory counsel. Unfortunately, I don't have a name that I can give you right now, but we will work on getting that person appointed. We will let them know that you're in custody here in Douglas County. And then hopefully once we get them appointed, they will be in touch with you. They will also be the folks that can help assist you in getting the discovery and those other pieces that you're requesting, okay?
Okay, and Your Honor, based on the conflict with the Public Defender's Office, will this person be with the Alternative Defense Counsel, or might they be with just the Public Defender's Office?
So, two things. I'm not finding a conflict with the Public Defender's Office, but that being said, the Public Defender's Office doesn't do advisory counsel cases, and so we will appoint somebody who is outside of the Public Defender's Office.
Understood.
All right. Do you have any other questions today, Mr. Bramshire?
Your Honor, I do, if I may take a couple just quick moments, brief moments of the court.
I'm going to ask that you be brief, okay, and stay on point.
Yeah. First,
If you're learning English for the first time, nothing you see resembles the word brief. Nothing.
First and foremost, under Colorado CJC Canyon 2, I want to thank you for the impartiality and fairness, Rule 2.2, and also under 2.6, ensuring that my right to be heard is heard. Your Honor, I do and I will file a motion to dismiss for outrageous governmental conduct. I want to read you this statement, only this, and I'll leave it at that. In re blem, which is referred to on Nirvar Jamadar's motion of competency at 9, and he uses this case against me, but at 944 it says duty bound to raise and resolve the issue of an accused competency whenever there is some doubt that that question exists. I'm going to refer you to Head Note 8 at 994 on that, but I want you to know is that Nirab Jamadar only visited me one time prior to our first hearing on March 3rd. And that...
Sir, you were found competent. You won that. It's over. You can move forward now.
hearing was under 10 minutes. And at this point in time, Your Honor, discussing this, I am waiving attorney-client privilege, but I am also invoking it. I am aware, based on case law, that attorney-client privilege attached during this consultation. This consultation was unsolicited. Under Colorado Rule of Professional Conduct 1.18A, it falls under possibility of forming a client-lawyer relationship as prospective client, at which time I did decline representation, Colorado Rule 1.16A3, and I discharged Jamadar from any idea that he was representing me. And that proves I never consented, as in given Jamadar, Colorado Rule of Professional Conduct 1.0E, informed consent to represent me in court and to say I was incompetent at that first court date, where on record, an icon, it says I wanted to go pro se. Your Honor, I am looking at this examination. Gugliano calls it a competency examination, but that is incorrect. This is a competency evaluation report. Under Colorado Revised Statute 16.8.5.1011, it states what can be used for collateral materials in proffering her opinion. She goes well beyond that with her communications with Nirab Jamadar. It says she spoke to him on the phone on the 18th and that they exchanged emails from March 12th until April 14th. This is in violation of the attorney-client privilege, and it offends me, and it's a violation of law and constitution as far as my due process rights go and equal protection rights as well. Your Honor, she even got records from the Your Honor, I have a lot of problems with this. I'll write you on it. But I just want to proffer once again that I will be motioning for dismissal of the cases under the due process claim about.
I think listen, sir, if you're going to motion for all of those cases to be dismissed, we're going to run out of paper in the United States.
Outrageous governmental conduct. And also I'll be asking that this evidence be removed, the examination, the report be denied as evidence. Your Honor, the case is People versus Ald. It's where a prosecutor participated in fraud against the court, and they had to drop the case. Your Honor, thank you for acknowledging my motion to the Colorado Supreme Court, and thank you for giving me the piece of paper that said I could proceed in form of papyrus. If you'll notice, twice in that, I accused Jamadar of fraud, and also one time in the competency report, the word fraud is used again. Your Honor, I never hired this guy. I never wanted him. I had 5
I apologize for all the F words in this stream, guys.
scripts that I pre-prepared that I would call every day after March 3rd and leave a message on the general voicemail of the public defenders or on R.O. Ohanian's. They would not give me Jamadar's direct extension. So every day I left a voicemail saying I was competent or saying this or that or the other thing. Your Honor, Nirab Jamadar is stated in this competency evaluation report at, I think 12 times this lady refers to him. She also directly quotes the Pueblo issue from 10693690, and she can't do that either. Your Honor, as far as the Colorado Revised Statute 16 8.5 104 waiver, it says specifically that the defendant must request the competency eval. I never did. Jamadar counsel did.
Your Honor, I would like one more case brought against him. He said he was going to be brief, therefore he lied on the stand.
So it doesn't say whether counsel did or anything, but it says if I do or you do, that I automatically waive that right. How can I waive a right if I'm supposedly incompetent in the first place? And then, Your Honor, last but not least, if I can draw your attention to Colorado Revised Statute 16 8.5 1021, it specifically states in there that when a defendant is incompetent to proceed, that certain things must be stayed, but pretrial issues that are capable of fair determination are okay. Now, under Colorado case law, I have the presumption of innocence. I don't have the case, but it's People versus Palmer, Colorado Supreme Court. That's where they refer to other.
My whole chat thinks you're guilty. There's not any of them who think you're innocent. I don't know. I'm just telling you what my chat thinks. I don't know.
State statutes, and then also under the Colorado rules of evidence, every witness is competent until proven differently, and I am a witness in my own case. So since I was competent,
you should be disbarred. You should be that's what he's trying to do, Stephen. He wants to get out of those bars.
and since you in your competency motion on the 3rd or the 4th of March said that you could not make a decision and that you did not have enough information, I have remained competent through this entire process. And that has been verified last Tuesday by Gugliano's evaluation report. So I have been competent this entire time, and the 16 8.5 1021 supersedes the speedy trial F6 or whatever it is that says that the stuff might be stayed. But the 16 8.5 1021, I think 2008, that's when the old statutes were repealed. That's when this statute came in. It says that it's only stayed, and only certain things are the trial and sentencing when somebody's incompetent. Again, under the presumption of competency.
So, Mr. Breacher, I gotta stop you, okay? Because we've resolved this issue today, and I recognize that it doesn't make up for lost time, and I can certainly appreciate that. But we've resolved the issue today. I've made the determination that you are competent to proceed. We're gonna work on getting advisory counsel appointed for you, and I'm gonna give you a new court date, okay?
Okay. Two things. I was getting help.
I got a lot of people who also need to be heard today.
Yeah, two things. I had the number for the court and was talking to the court, and they blocked my number, which was very mean. And now
I've never heard that before. The court blocked his number. But what does that mean? The court didn't block the jail. They just didn't, right? So that they block his cell phone? Well, that doesn't make sense because he doesn't have use of his cell phone. What does that mean, they blocked his number? And I've never heard of the courthouse doing that before, but it's hilarious.
now that I'm pro se, and I wasn't mean to them, that's how I got the icon, and I had asked for discovery, and then they blocked my number. Can you unblock that? And then one further thing, I need a court order from you to release my cell phone to my uncle. What happened is they're telling me that after.
He finally brought up a good point, guys. He needs his cell phone back. That's a good point.
For 14 days of incarceration, that you can't release any property, and they're also saying that you have to describe to them whatever emergency it is, which doesn't allow, which isn't fair, and so technically under the 4th Amendment they've seized my phone, and I need to release that to my uncle. Can I please have a court order forcing the jail to release my property to my uncle, please? It's not involved in the crime. It's not seized as part of the crime. My uncle is requiring it because he wants access to my bank account so that I can bond out, and he has access to the money to bond me out, Your Honor. Please give me a court order that the jail has to release the phone. I have many.
All right, Mr. Bramshire. Okay, hang tight. So I'm going to get you a new court date. I can have you come back to see me on June 16th at 9 a.m. and hopefully we'll have advisory council in place and they will have spoken to you before that court date, okay?
Okay, but then before that, Your Honor, let's do I haven't been able to afford bond, and under the statute I sent you on the kites, 16 or whatever, if you can't afford the bond, you get a new bond hearing. Can we schedule a new bond hearing
No,
within
that's
the
not
next 7
exactly
days?
true, Mr. Bramsher. There has to be a change in circumstances and just
Your
not
Honor?
being able to. Mr. Bramsher,
There
please
is.
stop interrupting me, okay? I've given you an opportunity to speak. I've heard you out. I'm not going to readdress bond today. Let's get this advisory council in place. Let them talk to you. See if they can help you obtain discovery and whatever other requests that you may have, okay?
Your Honor, 22 of my charges are 18-9-111-1E. That was
Mr.
ruled
Bramsher, I've heard
unconstitutional
this
in
before, and I'm not
2022.
going to address bond again today, okay?
Within 7 days, within 7 days, you have to do a hearing. That's what the statute says. It's in the kite I sent you. I'm not prepared because I
Bramsher,
thought our
I'm
court was
not
tomorrow.
going to address bond today. I'm going to reset you
18-9-111 is harassment. I don't know about E.
for June 16th at 9, and then we'll get advisory council put in place, okay?
All right, Your Honor, I have the motion filed with the Supreme Court of Colorado. Rock and roll. I'm ready to play. See you
Go
soon.
ahead, file it, okay? Take
It's already
care.
filed. You know it is.
He's telling on you, ma'am. He's talking to your superiors.
Is this an add-on?
All right. We're going to keep an eye on that guy. That guy. Don't you worry. We're going to make sure we follow what's going on with him. Now, so we're going to see part of a trial. Just you know, a half hour or so of this trial. We're going to see some opening statements. We're going to hear some testimony. We're going to listen to the closing statements, and we're going to listen to the jury verdict. If you want to watch the entire trial, I hope that's not a B. I'm going to put it up in the members only area. I have to put comments. I have to put comments every once in a while so YouTube doesn't get mad at me. So you can just ignore them. I didn't put effort into them. But it will be in the members only area if you do want to see the whole trial.
Statements from the prosecution.
Mr. Turner, could I make use of the screen, please?
Yes.
And Your Honor, if I may have the handheld microphone so I can move out the well.
Sure.
Thank you. On September 14th of 2025, Keith Sanders calls 911. Keith Sanders is the reporting party in this case. He was neighbors at the time with the defendant, Tiffany Schneid, and Wayne Monroe, the victim in this case. The reason he called 911 is because for quite some time, about an hour, he had heard Tiffany yelling and screaming, and he had been hearing things, what sounded to him like things being thrown about the apartment or the residence. And he called 911 ultimately because he was afraid that Tiffany was going to hurt Wayne. Law enforcement arrives on scene to Tiffany and Wayne's residence, and the residence is in disarray. This photo on the left, you're going to learn, is the hallway leading up to the bedroom. So where you're facing is kind of out of the bedroom. And what's on the floor there is some broken glass and food that seems to have been thrown. The glass is shattered. Those are just close-up pictures you'll see. You'll get to see these later as well, of that thrown plate or bowl of food. This is Wayne. Law enforcement interviewed him when they arrived on scene. When they arrived on scene, he was not wearing a shirt. He had some redness to the right side of his face. And they interview him and they ask him what happened. You're going to hear today from the deputy that spoke to him that he was a little bit
2 snaps in a circle for this audio. Crystal clear.
hesitant to come forward and kind of say what happened. He starts off and says, maybe it got physical. And law enforcement says, well, is it maybe or is it yes? And eventually, after a while, he says, yes, she slapped me. Specifically, the chain of events that you're going to hear what happened is on the 13th, the night before, Wayne and Tiffany had been arguing. And at one point, probably due to some of the disarray in the house, is because at one point, Wayne says she started tearing up floorboards from the floor. He had tried to get her to stop, accidentally stepped on her finger while she was doing it, and then he left the residence. And then when he returned in the morning, they started arguing again about him leaving the night before. While they were arguing, she tore his shirt, the one he wasn't wearing when law enforcement arrived on scene. She slapped him with her left hand on the right side of his face, and then she threw that bowl of oatmeal and caused it to shatter inside of the residence. It's because of this chain of events and these actions of Ms. Schneid that we've charged her with 2 counts in this case, and the first count is harassment. Now, the judge is going to instruct you on the law later, and I will certainly talk about it in more detail in closing arguments. But harassment essentially is the act of striking, shoving, kicking, subjecting someone to physical contact, any of those things combined with a culpable state of mind, the intent to harass, annoy, or alarm. During this trial, I want you to pay attention to a few facts as you're thinking about that. This argument was about Wayne leaving. The reporting party had heard Tiffany yelling and screaming for over an hour before he decided to call police due to the disturbance. And it was during the course of this argument that Tiffany tore his shirt and she slapped Wayne on the right side of his face. The second count is criminal mischief. Again, you'll be instructed on this later by the judge. You should listen closely to that. Essentially, again, an act of the culpable state of mind. It's essentially damaging the property of another person that includes jointly owned property and doing it knowingly. And during the course of this trial, you're going to learn evidence that also during the argument, during this course of events, she threw that bowl of oatmeal and caused it to shatter. She threw it at the bedroom door. And that is the result of what she did. Now, we've also charged these crimes, both of them, as crimes of domestic violence.
If throwing oatmeal is a crime, every single one of my children are criminals. Should have locked them up when they were 2.
And this is the definition of domestic violence that you'll see in your jury instructions later. It's any crime against a person with whom someone has been in an intimate relationship when used as a method of coercion, control, punishment, intimidation, or revenge. You're going to learn through the course of this trial that Wayne and Tiffany were intimate partners for a very, very long time and were living together. And the cause of all of these actions by Tiffany, the reason she did all of these things, you'll learn is because he was trying to leave. That's why at the end of the trial, I'm going to ask that you render a verdict of guilty on both counts. And you also find that they were both acts of domestic violence. Thank you.
All right, thank you. Does the defense wish to make an opening statement at this time?
We do, Judge. So you're going to hear a lot today about what happened between the evening before and the day of. You're going to hear that there was a lot of fighting going on. You're going to hear that there was screaming, that there was yelling, that there were disagreements between Tiffany and Wayne. You're going to hear that the night before police arrived, that there was some construction going on in the house. And you're going to hear that Tiffany was pulling up floorboards as part of that construction. And you're going to hear that Wayne stepped on the crowbar she was using and injured her finger. The next morning, after Wayne comes back, the argument continues. There is yelling, absolutely. You're going to hear from Wayne himself and from law enforcement, and you're going to hear that Tiffany was going through one of the worst parts of her life. You're going to hear details about that, but you're going to hear that she was extremely emotional for a variety of reasons. You're also going to hear that when police showed up, Tiffany didn't want to talk to them. On top of everything else that she was dealing with, she did not want to talk to them. You'll hear that officers did talk to Wayne, and they got his side of the story. You'll hear that one female officer, who was the officer that Tiffany was willing to talk to her for 30 minutes. Talked to her about this bloody injury on her finger. This female officer talks to her about what's been happening. And Tiffany is still incredibly emotional Like I said, you'll hear a little bit more about why that is later, but this officer talks to Tiffany for 30 minutes. Other officers talk to Wayne. And at some point, they decide she's the crazy one, she's the emotional one, and without even speaking to Officer Culp, who's the officer that spoke to Tiffany, without even hearing about that 30-minute conversation, they decide she's crazy, she's yelling, she's emotional, we're going to arrest her. And they do. And after they arrest her, they take her to the hospital before taking her to the jail to get treated for this injury on her finger. No one takes any pictures of it. Nobody besides Officer Culp asks any questions about it. But they decided that she was the crazy one, that she was the emotional one, and that she was the one that was going to jail. And you're going to hear from several witnesses today, and you get to judge their
I was just happy it wasn't me for once.
credibility. You get to determine what they saw. You get to decide their credibility on the stand. You get to decide that. But at the end of this trial, it will be abundantly clear that police arrived on scene because a neighbor heard yelling. And we're not disputing that. Absolutely, there was yelling. They were emotional. And when police speak to Wayne outside of that house, when they arrive, he tells them he wants her to stop bitching and venting. That's what he wants. That he's been hearing it for the past 2 days, and that he wants her to stop bitching and venting. So at the end of this trial, we'll ask you to return a not guilty verdict because police jumped to conclusions.
Bobby, nice.
They heard this woman who was emotional. She was distraught. She was dealing with some of the hardest things that any person can really deal with. And that caused strife in their relationship. But when police arrived, after neighbors called the police, they decided she's emotional, she's uncooperative, she doesn't want to talk to us, and so we're going to arrest her. They jumped to conclusions. But you, being sworn in as this jury, have an obligation to listen to all of the evidence. All of the evidence from officers, from Wayne, Mr. Monroe, and decide whether she's guilty or not. And after the completion of all the evidence, Ms. Competency is going to come back up here and ask you to render the only just verdict in this case, which is not guilty. Thank you.
Thank you, Ms. Dayton.
All right, Deputy, we should be able to see it now. All right, so this is that still from body worn camera, correct?
It is.
And as we can see right by the door, there's a big stack of wooden planks, right?
Yep.
And the rest of the floor was pretty much covered in something similar, right?
Correct.
Okay. Now, when you walked inside, you found Miss Kramer eventually sitting in a closet, correct?
Yes.
And she was visibly crying and upset, right?
Correct.
And then Deputy Culp was the officer who actually ended up staying and speaking with Miss Schneid, right?
Correct.
And that's when you went to speak to Keith Sanders, correct?
Correct.
Okay. And after speaking to Mr. Sanders, you went inside, and that's when you were informed that Ms. Schneid was going to be arrested, right?
Correct.
Now, you hadn't spoken to Ms. Schneid or Officer Culp yet, right?
I had not.
And so after being told that she was going to be arrested, that's when you did arrest Ms. Schneid, right?
Correct.
And I know you mentioned earlier, you noticed that she didn't have a bra on. She did ask if she could put a bra on, right?
I don't recall.
Okay. But you guys didn't give her an opportunity to put a bra on before arresting her.
She was pretty aggressive and hostile. Once we showed up, I realized that she was pretty emotional, pretty distraught while talking to Deputy Culp. And once she was placed into custody, I don't recall her asking. But if she had, I do believe that we probably would not have taken off the handcuffs to try to make that accommodation.
And you guys didn't let her put on shoes either when you arrested her?
Not that I recall.
Okay. And then, Deputy, you stated that you took photos of what we see regarding the oatmeal, right?
Correct?
You don't know how long that had been there?
No.
Okay. And you are not sure how it got there?
Nope.
Okay. And then you took photos of Mr. Monroe's face, right?
Yes.
And you made note that when you took pictures of his face, you noticed the cuts were starting to scab, right?
Correct.
You'd agree that if a wound is starting to scab, that means it usually didn't happen recently, right?
To expert testimony.
Runner,
I think the witness can answer, but based on common everyday experience, this deputy can answer the questions.
Okay. I agree that I did make note that there were scabs on the face, or it had started to scab. I don't think that was really to the point of the photo. The photo was that he had been slapped across the face versus being scratched.
I understand that, Deputy. But once again, just back to my question.
Mhm.
When something is starting to scab over already, it usually hasn't happened, a wound hasn't happened recently, you'd say.
Correct.
Okay. And then you were, obviously, as we saw, you walked around the house and took some photos and collected evidence, right?
Correct.
And you never found a shirt that was ripped up, right?
No.
Okay. And I know we established that Ms. Schneid's hand was injured. You never took photos of that hand, did you?
No.
Okay. No further questions, Your Honor.
Redirect examination?
Yes, Your Honor. So you're asked.
Thank you so much. Thank you so much, Martha. You got Steven and you got Spirit. That's awesome. Thank you.
About a taser on cross-examination. Why did you take your taser out?
Before entering the residence, because she did lock us out and was not compliant with our initial investigation. Her domestic partner, Wayne, allowed us access to the home, gave us his keys. He said there wasn't any weapons.
Objection, Your Honor, to hearsay at this point.
Overruled.
Wayne said there wasn't any access to firearms in the home. If she had any weapons, it'd probably be something like a kitchen knife. So, as a precaution, I used my taser and the warning sound to advise her that if she did try to attack us, based on her prior behavior, that she would be subject to tasing.
Did you ever actually deploy your taser?
I did not.
And on cross-examination, you were asked about a brief interaction with Ms. Schneid. Could you smell anything when you were talking to her?
I think I noted in my report that I observed alcohol bottles and I could smell alcohol in her breath. And while doing the our domestic violence investigation packet with Wayne later, after Tiffany had been removed from the scene, he said that she...
Objection, Your Honor, to hearsay again.
Sustained.
And we can defend there, Deputy.
Okay. I did smell alcohol in her breath, and I was told that there was...
So, Deputy, please don't volunteer anything that someone else told you.
Yes, sir. I smelled alcohol in her breath.
Okay, nothing further.
Does the jury have any questions for this witness? Yeah, so go ahead and write it out if you would, and then you'll hand the sheet of paper to Christina.
This case is about control. She was trying to control the situation, and she was trying to control Wayne. Heard all the evidence that you're going to hear in this case. You have everything that you need to consider when you're coming to your verdicts and your deliberation. So now I want to talk to you more about the law, like I promised I would in opening statements. The first count, like I said before, is harassment. The elements of that charge are that the defendant in the state of Colorado at or about in the date and place charged with intent to harass, annoy, or alarm another person, strike, shoved, kicked, subjected them to physical contact. So the first kind of part of this charge is intent to harass, annoy, or alarm. So let's talk about evidence of her intent that you heard today. This started because Tiffany and Wayne were arguing, and Wayne didn't really ever explain why the argument started to begin with on the night of the 13th. But on the 14th, the date that she's charged with these crimes, they were in an argument about him leaving the night before. That's why he said the argument started up again. The reporting party also heard that first witness who testified, Keith. He heard Tiffany yelling and screaming for over an hour before he called the police. And he said that both of them were screaming, but it was mostly Tiffany who was yelling at Wayne. The second part of this charge is the act. That's striking another person, shoving them. The only ones really applicable in this case for striking or subjecting someone to physical contact.
Screaming and yelling for over an hour is hard work. It's rough. It takes a lot.
So that's what we're going to talk about here. She slapped him across the face. That's striking someone. The reporting party saw this happen. Now, I anticipate the defense will probably get up here and talk to you about the burden of proof, and that is important. But if you believe the reporting party that he saw this happen, that's beyond a reasonable doubt. You also have an injury. There's redness on the right side of his face. I want to talk about victim recantation. We touched a lot about male victims of domestic violence in voir dire. One thing that you can consider that was in your jury instructions that were just read to you and that you can see when printed out one is that witness credibility instruction. And it tells you that you can consider the circumstances under which each witness has testified. That includes considering their motive for testifying today and their relationship to either side of the case. We all saw Wayne testify here today. We saw his demeanor. The circumstances under which he has testified today is he's testifying against his girlfriend of 9 years. They have lived together for 8 years. Then you can consider what motive he might have in testifying today. You heard testimony from him on the stand that this slap across the face and the tearing of his shirt were an accident because she had tripped and fallen. But you heard testimony from the officer who spoke to him twice on scene that day, Deputy Hernandez, that last police officer. Not once did he tell police that it was an accident that day. They talked to him right after it happened. And there's body-worn camera that you can also rewatch during your deliberations. This wasn't something he was excited to report to law enforcement that day. They said, Deputy Hernandez said, "Did anything get physical?" He's like, "Maybe." And Deputy Hernandez said, "Well, is it maybe or is it yes?" And you saw the questioning that it took to get out of him when he finally said, "Yes, she slapped me across the face, but she was just letting off steam." That's what he said. He didn't want to report this, but it's still a crime. And during jury selection, you all said you could follow the law.
I get bail.
I want to talk now about the second count, and that's criminal mischief. That is knowingly damaging the real or personal property of one or more persons, including property owned jointly by the defendant and another person. So you saw evidence today of this smashed oatmeal bowl. There's pictures of that. Wayne said on the stand he did not throw that. He never said he threw it. He told you on the stand that he never said that she chucked the oatmeal bowl at the door, but that body-worn camera that was played, he says to Deputy Hernandez, "Yeah, she chucked that at the door while they were arguing." You also heard evidence today that she tore Wayne's shirt. That's a shirt that he had been wearing. That also is criminal mischief. That's damaging the real or personal property of another person. So not only does she have to have done this, but she has to have done it knowingly. So let's talk about that, because that did become...
Did he even try to tell her to just calm down? I wonder. Did he tell her she was overreacting maybe?
An issue when Wayne testified. He said on the stand that she was upset and they were arguing, but this was an accident. She ripped his shirt because she had tripped over some floorboards. Again, he never told that to law enforcement. There were multiple officers on scene that day. They were questioning Tiffany. He never mentioned on scene that it was an accident. He agreed it's important to be truthful with law enforcement when you're speaking with them. This wasn't an accident. She did it knowingly. This was part of the course of conduct of her crashing out during the argument. They got into an argument about him leaving. The reporting party again heard her screaming and yelling for over an hour. She was very upset. Wayne was also trying to leave the morning of the 14th when she smashed this bowl and ripped his shirt. That's knowingly. Last thing I want to touch on here is domestic violence, and we talked about this in the opening statement and a lot in voir dire. But domestic violence is defined in Colorado, and you were just read two different versions of it. There's one version that is an act of violence against a person you're in an intimate relationship with. That's really straightforward. That's how most people understand domestic violence to be. But domestic violence in Colorado is also any crime against a person when used as a method of control directed against a person with whom the actor has been in an intimate relationship. When we talk about an intimate relationship, that's beyond a reasonable doubt here. Wayne said they've been dating for 9 years. She is his girlfriend. She was at the time. They have lived together for 8 years. They are in an intimate relationship, and they were in September of 2025. But I want to talk about control because that's really the one that this is. You have body-worn camera of Wayne quoting Tiffany saying, "You're not going anywhere. You ain't going nowhere." He said that he tried to leave during the course of the argument, and she followed him out of the house and got into the truck before he could get into it so that he couldn't leave. She's trying to control the situation, and she's trying to control him. At the end of the day, this isn't the crime of the century. She's not on trial for murdering someone or anything like that. But this is a violation of Colorado state law. And your job as jurors is to apply the facts and the evidence to the law in this case.
Okay, all right. Listen, guys. Now the defense attorney is about to get up and tell us a whole bunch of other facts that we didn't know yet that are interesting.
This case is about control. It's about her slapping him across the face, smashing something, and ripping his shirt. It's against the law in Colorado. And that's why I'm asking that you find her guilty of both counts and you find that both were acts of domestic violence. Thank you.
I think it is the defense wish to make a closing at this time.
Yes, Your Honor, if I could have one moment. And Your Honor, if I could also connect.
Yep, it's on your output now.
On the date of her arrest, Ms. Schneid was upset. She was emotional. She was a mess, but she didn't commit a crime. What Ms. Dayton talked to you guys about during opening was about how this investigation was done. And it was that it was decided that regardless of her injuries, regardless of Mr. Monroe's own admitting to injuring her, regardless of the fact that they saw her fingers actively bleeding, they decided that she was the crazy lady who needed to be arrested. It was pretty clear during Deputy Gonzalez's testimony
Throw up your link.
that when I simply asked him if he saw her injured finger, he quickly decided to talk about anything but that, including volunteering that she was scantily dressed, not wearing a bra, her hair was a mess. She yelled at him, "Wayne did this to me, arrest me," and slammed the door in his face. You may be listening to that testimony thinking, that's not how I would have interacted with the police. And you may not have. But that's not your decision today. Your decision
What does the way she was dressed have to do with anything? What I don't understand.
Decision today isn't should Ms. Schneid have not slammed that door in Deputy Gonzalez's face. At the end of the day, Deputy Gonzalez saw Ms. Schneid, and what he remembered was that her boobs were out, that she was yelling at him, and that she slammed the door in his face, and that she was, after her arrest, was trying to resist that when they dragged her out of the house without a bra on and without shoes on. When Deputy Gonzalez came into the house, even though the only witness he spoke to stated that he never saw any physical contact, he heard, "We're taking her in," and he jumped at it. He is the one that handcuffed her and arrested her because he didn't doubt for a second, simply based on their interaction, that she needed to go. Now, the other person who wanted Ms. Schneid to stop with her emotions, with her being upset, with her yelling, was Wayne Monroe, who on that day talked about to these officers how she had been bitching and venting since last night. Her father had died unexpectedly, and as you heard, she was upset. She was distraught, and so she decided to take out that grief, that frustration, those emotions by working on a project that they had been planning on working on anyway. She took that crowbar and started taking those floorboards off the ground. But Miss Monroe was frustrated. He was pissed. They'd been arguing, and now she's doing something that he sees as unnecessary, that she shouldn't be doing at 9:30. And so he steps on that crowbar to stop her and smashes her finger. And that's when he leaves. When things got a little too far on his end, that's when he left the home. When he comes back that next day, Miss Schneid is still emotional. She's still distraught because she is dealing with that grief, and she's upset. And so Mr. Monroe comes into this with her, as he said, bitching and venting all over again. And he goes to leave, and she walks out to the car and gets in the car. And then at that moment, you hear that he closes the door and it slams on her fingers. A second injury that he caused. They go back into the home. They're arguing. And then you heard Mr. Monroe today that as they're arguing in this house, with that being the floor, she fell, and that's when she made contact with him. Now, the prosecution already went over this, and I want to be clear. When Mr. Sanders, who told all the officers that it never became physical, talked about how he did see her make contact with his face, no one here is arguing, it's clear from the testimony, that she didn't make some sort of contact with him with her hands. But that's not enough. What they had to prove to you beyond a reasonable doubt was that that contact was made with intent to harass, annoy, or alarm another person. And they called Wayne Monroe to the stand. That was evidence they presented to you, his own testimony under oath, that actually he was pissed at her that day. He was pissed at her because he was exhausted and he didn't want to keep dealing with her bitching and venting. He wanted her to stop. He wanted her to get help. Now, the prosecution is talking about his demeanor and how it seems that he's being dismissive, but it's also, his story is unclear. It doesn't add up. He's making things up as he goes. He's changing his story over and over again. They talked to you about motive. Members of the jury, on that date, Mr. Monroe had hurt Ms. Schneid 2 separate times. The only wound that anyone talked about actively bleeding was Ms. Schneid's, and he didn't tell those officers that day about slamming her fingers in the door. He admitted to stepping on a the pry bar and accidentally hurting her, but stepping on that pry bar is not an accident. It was an intention, and he knows he messed up. But he was here today to testify about what really happened when he's not in front of these officers who are asking him, what happened to her fingers? When he's not asking these officers, is she going to get some therapy at the jail? Is she going to get some sort of mental help? He wanted her to stop. He wanted her to get help. And so he was going to tell this story that kept changing throughout the day because he wanted her to leave and he wanted someone else to deal with what she was going through. They also talked about how, and they acknowledged that they had to prove beyond a reasonable doubt that she knowingly damaged the real or personal property of one or more other persons. Members of the jury, it is not a crime to break your own property when you're emotional. It is not a crime to break your own property when you're frustrated. That would be insane. If you are talking on your phone and you're frustrated and you throw it on the ground and now suddenly you're being arrested and accused of a crime, that's not how criminal mischief works. Read the jury instruction. It talks about how it has to be joint property. It has to be property that is also owned by maybe her or maybe another, but they didn't provide any testimony. All that we heard was that was her oatmeal and she threw that bowl on the ground out of frustration. And this shirt. I mean, I know we talked about this shirt so many times, and that was part of Wayne's story on that day, and he talked about it today, but those deputies did a search of the house. They took many photos. They looked throughout it, and no one could find this alleged shirt. You don't even get to see a torn up shirt. You don't even get to see property that was allegedly damaged. They took plenty of photos that day. And a big thing that they're trying to argue shows that she did commit the crime of harassment is that he had a cut on his face that Deputy Gonzalez had to admit it was scabbed. And they're trying to force you, they're trying to throw things at you by saying, okay, so obviously she did slap him with intent to harass, annoy, or alarm him because he had a cut on his face. But Deputy Gonzalez had to admit, if something's scabbing over, it means it probably didn't happen recently. It probably didn't happen minutes ago, a couple minutes ago, like Mr. Monroe claimed the slap happened. So this wound that they did show wasn't even a recent one. And Mr. Monroe said, I get cuts and nicks all the time. But one injury that we didn't get to see today, that they didn't take a single photograph of, even though they took her to the hospital for it, was her own fingers that had been smashed. Because they decided that they didn't need that. They had everything they needed that they wanted to have to arrest the crazy lady who was rude to them, who yelled at them. They didn't feel it was necessary, even though Deputy Hernandez acknowledged that there were 2 crime scenes that day. The incident from the night before and the incident from that morning, but we only got to see the crime scene that they decided was the one that was more important.
Sorry, you have 5 minutes.
Thank you, Your Honor. We didn't get to see any evidence of that other crime scene because they had already made their decision by that point, members of the jury. They were going to arrest the emotional crazy lady who disrespected them, that they felt the need to pull out a taser and say, Miss Schneid, do you hear my taser? And they find her crying in the closet. Members of the jury, obviously you're going to get your jury instructions, and you all have sworn to uphold your duty and read that and read the law. It talks about this beyond a reasonable doubt, this standard that we talked about. That's not the standard officers need to arrest someone. It's not. They need probable cause, and if there's allegations like you heard of any domestic violence, they have to arrest someone. So even if you're sitting here thinking, well, they were just doing the best they could, you can think that, but you can still acknowledge that your duty is different than theirs.
Thank you for the tears, Monica. Thank you.
You don't decide which crime scene matters more. You don't decide that her injuries actually don't matter and ignore it. You, as a jury, have to consider all of the evidence, even evidence that the police didn't provide to you today. And even when they did talk about probable cause, we didn't hear from any of these officers that spoke to Miss Schneid. We didn't hear from the officer who decided that they needed to arrest Miss Schneid. We didn't hear about any of that. But beyond a reasonable doubt is the highest standard in our legal system because this is a criminal conviction. These are crimes that you are deciding if the government brought forth against my client and then proved beyond a reasonable doubt that she's guilty. And there's a definition in there. It talks about how beyond a reasonable doubt is beyond such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you go back there with questions and you think, why didn't they look more into her fingers? Why didn't they call Officer Boyd? Why did these officers talk about her appearance and how she acted towards them rather than the other evidence in this case? When you go back there with questions, when you hesitate, that's reasonable doubt. We're not asking you to decide if Ms. Schneid handled the situation with the officers right that day. We're asking you to do your duty you've sworn to do. And that's consider all of the evidence. And when you actually consider it, when you think about their own witnesses they called to testify today, you will see that Ms. Schneid was labeled as a crazy woman who was being disrespectful to officers, to the point where they whipped out a taser, started making the noise with it when they went inside. And they decided to believe Mr. Monroe, who was the calm one, whose story kept changing, but that was a way for everyone in that situation to be done with her. That's not beyond a reasonable doubt. And we're asking you to hold the government to their duty and find that they did not prove that, because you will go back there with questions that are unanswered, and that is reasonable doubt. So we will ask you to find her not guilty, because if you recognize they did not meet their burden, you don't even go to the domestic violence part because she didn't commit a crime that day. She was emotional, she was a mess, and she was a problem for everyone there. But she didn't commit a crime. We're asking you to give her the fair chance that she deserves and look at everything and find that she's not guilty. Thank you.
Thank you, Ms. Kasemsi. So the prosecution has the burden of proof in this case, so they are permitted to make a rebuttal closing argument if they'd like within their original allotted time. And you have 7 minutes remaining, Ms. Hanine.
She does not use 7 minutes.
I want to talk about these quotes that the defense said. She's the crazy one. She was a problem for everyone there. The only person who has said that today is the defense attorney. None of the witnesses testifying said any of that. I never said that. No one is arguing that with the defense. I want to mention this point because much of the defense's argument relies on deflecting and distracting from the elements of the crime. And I want to remind you that Wayne Monroe is not on trial today. You don't have to like him. But was a crime committed against him? Yes. I want to talk about what the law says in terms of reasonable doubt, what the law says in terms of the elements of harassment. The law does not say that you can't have questions. You can have questions, but do they go to an element of the offense charged? If they do not go to an element of the offense charged, that's still beyond a reasonable doubt. These are the elements of harassment, again, that I showed you. Opening, first close. There are 5 of them. There is no 6th element that says unless in your jury instructions. If she did those things with the requisite intent, she is guilty. There's no unless he accidentally stepped on her finger the night before. There's no unless he accidentally slammed her finger into a car. The defense, was insinuating that might have been intentional. There's been no evidence of that. There's no unless he said she was bitching and moaning. If these 5 elements are met, she is guilty of harassment. She slapped him across the face because she was pissed that he was leaving. Again, she's not guilty if he was also mad at her, if he was also annoyed, if he thought she was being crazy, which he never said. It was insinuated a lot by the defense, but no one is calling her crazy really except for them. But there is no 6th element here. That's it. That's what the law says. Your job is to follow the law. Defense said, made a lot of insinuations about Wayne's credibility today. His story is unclear and he's changing his story. And maybe we're insinuating because he might have been, thought he did something wrong on scene. He did change his story today. He said, she tripped. She slapped me, and she ripped my shirt, but she tripped. He didn't say that on scene. Why is he saying that now? Seriously? She tripped. Just want to stress again, look at the elements of the crime. Look at the evidence of her intent. Think about what the witnesses said. Look at your notes. Think about the reporting party who said he saw her slap him. Why would he make that up today? And I ask that you just find her guilty of all counts and you find their crimes of domestic violence. Thank you.
Reached verdict.
But like I said, Micah, I put the entire trial with all of the witnesses up in the members only area. So maybe the answer's in there. I don't know.
Did the victim say anything about wanting to be present when the verdict is read?
I don't think that he did. I'm not seeing anything from the notes with our specialist about that.
Okay, we are live streaming the proceedings, so if the victim would like to observe, he'll have that option. All right, we'll bring the jury in now. All right, welcome back to our jury. Please, everyone, be seated. Let me look at my chart here. I believe jury number 9. I see you have the paperwork. Are you our foreperson?
I am.
And has the foreperson reached a unanimous verdict as to these 2 counts?
Yes.
Would you hand the paperwork to Christina, please? All right, the court will now announce the jury's verdicts. The first is as to count number 1, the charge of harassment in the People of the State of Colorado versus Tiffany Schneid. Option 1 is signed, indicating the jury has found the defendant not guilty of harassment. And then the verdict interrogatory concerning domestic violence is appropriately not answered. Jury verdict count 2, the charge of criminal mischief. Option 1 is signed, indicating the jury has found the defendant not guilty of criminal mischief. And then there too, the question about domestic violence is appropriately not responded to. On behalf of the people, are you requesting a polling of the jury?
No, Your Honor.
Is the defense?
No, Judge, I don't believe so.
No, Your Honor, apologies.
Not guilty.
Okay, you all can be seated. Thank you. Turning back to our jury, the verdict having been rendered, that concludes your service as jurors. The last instruction is just this. It concerns who you can talk to about your service. And the answer is anyone you'd like. All the rules about secrecy and not doing any independent investigation or research, those are all withdrawn. You now are welcome to speak with anyone. You sometimes lawyers or parties will reach out to you with just questions about what did you see, what influenced your verdict. It's totally appropriate for them to do that. They're just looking for feedback that might help them be better and get better in the future. And if you're willing to talk with them, great. If you're not, though, if you're not interested in speaking with them, let them know that, and I'm sure they will leave you alone. But otherwise, with the thanks of the parties and the sincere thanks of the court, thank you very much for your service. You all are dismissed. Jenny or Christine will walk you back to the deliberation room where you can gather up your things, and then they will take you to the exits. If any of you have any questions or any feedback you'd like to pass along through me, I'm happy to head back there in just a minute. Just let Jenny or Christina know that, and I'll be back in just a second to answer any questions you all might have. One last time, with the thanks of the court, we're going to stand while the jury retires. Thank you all for your service.
And she gets to go home now. All right. Again, the whole trial is in the members only area if you want to see the whole trial, which I see that you really don't, because once I started playing this trial, we lost a bunch of viewers. I see that you hated that one. I'm sorry. I didn't know it was going to be hated, but it's okay. All right. We're going to go to a guy who needs to speak to his pastor. All right. That'll be better.
With counsel, Ms. Jones, and then we've got, I think, Ms. Archuleta with Bridges with us. Is that right? Okay, perfect. We're scheduled here today.
Yo, this poor judge lately has had a string of interesting people come into his courtroom. He just doesn't get a break.
For a status hearing concerning competency and bond and what we're going to do in Mr. Karp's case. What I can let the parties know is that I did refer Mr. Karp go ahead, Ms. Welch.
Thank you, Your Honor. I actually have some paperwork that I was supposed to give to Miss Jones, but.
Okay, perfect. Is it maybe about that? Okay.
Yes, Your
perfect.
Honor.
Yeah, I actually have, so we went to visit Mr. Karp a couple of days ago and spoke to him about the wraparound diversion program. He's not interested in moving forward with the diversion.
Okay. All right. Well, then it sounds like it's somewhat of a voluntary program, and so we probably wouldn't be able to do that then, unfortunately. That sort of leaves me with limited options in terms of what I can do then. I'm not sure what I can do. And so I guess let me go to Ms. Archuleta first. Ms. Archuleta, any information that you had for the court for today?
No, Your Honor, I was just reappointed to him to work with Mr. Karp today. So I haven't had an opportunity to meet with him on this case. He was assigned to me previously.
Sure.
But it has been a
couple months.
Yes. So I do plan on meeting with him, whether that be in the jail or in the community, and we can look at restoration houses. That could be a potential option if he's interested in.
That's what I would love to look at if it's a possibility, and so I really appreciate that. Thank you for letting me know. Okay. Let me go over to Ms. Jones. Ms. Jones?
I mean, we are still working on potential options for Mr. Karp. There's someone in my office, Ms. Gregory, recommended potentially the rapid stabilization program.
I would like a rapid stabilization program. I need that. But Michael, I was thinking if you and Nan got together, you would have a great breakfast item. All right, we have the oatmeal. Now, Maiko says we need to put peanut butter in the oatmeal. It's delicious. Nan says she likes the banana butter in oatmeal. Banana butter and peanut butter and the oatmeal together would be just too much. It'd be delicious.
Mr. Karp does represent that he does have housing, so it would be, I think, a little bit easier for him to do that if he did have housing.
What would his housing be?
He has stated that he lives in the Redlands.
Is that a recent development, or has he been living out there for a while?
How long have you been out there?
Born and raised.
So it doesn't sound recent.
Ma'am, I'll come to you in a second. Just wait though, okay? But you said it's been for, okay. Go ahead, Ms.
He
Jones.
says that he's born and raised in the Redlands. I'm unable to give the court any more
Sure.
information
Mine in the will.
than that. I mean, we also have case advocates on that we could get on his case to help with any kind of housing. I am also not sure what I would like. Mr. Karp does not want to be in custody. I would like to readdress bond. If not today, then I would ask that the court set a hearing for bond.
We can address bond today. The only thing that's prohibiting me modifying the bond is your client's position right now.
Okay. I mean, the only reason I asked to address bond is I don't know that the court made findings after you found that he was incompetent to proceed, that there were extraordinary circumstances preventing him from getting that presumptive PR bond.
There's not a presumptive PR bond. It's a class 1 misdemeanor. It's not a 16-4-113 situation.
No,
It's charged with.
I'm referring to 16-85111. It was my understanding that after there is a finding
Oh,
of ITP, there is a presumptive PR bond.
sure. We have not addressed that statute yet.
I mean, I understand the court's concerns with housing, but he does now have someone from Bridges. I could also get a case advocate from our office. I would ask that the court give him an opportunity to do this outside of custody. I understand that this is a class 1 misdemeanor.
Ms. Jones, I apologize for interrupting you, but the only reason I'm not modifying the bond is your client won't acknowledge or abide by the protection order. And so is that something that he will do or no? That's the only thing that matters from my perspective at this point.
My concern is that his mental health is not stable enough to be able to make any kind of informed decision or even represent to the court whether he is going to follow it. I think that the court could ask a different person in a different position who is not in competency proceedings whether they would abide by the protection order, and they would say yes, regardless of their intent. I don't think that not abiding or not saying that he will abide by this protection order is an extraordinary circumstance under 1611 or 16-85111 to keep him in custody.
He's threatening to shoot up the church and the people at the church that he's being restrained from. And so the court
Do you have that recorded? Do you have that
disagrees with
recorded
that.
Do you have
Disagree.
that recorded somewhere?
1 second, Mr. Karp. Disagrees with that characterization.
Never
If Mr. Karp will follow the protection order and acknowledge it, that's a non-monetary bond condition that I can impose that can address my concern. But the issue that I'm having right now with Mr. Karp is that he doesn't seem to be willing or able to understand the protection order or comply with it. And I've given him multiple opportunities to talk to me about this issue and just respond, and I've made no headway thus far. And so I'm willing to talk to him again about it here today, but do you have any updates on if you would or not, Ms. Jones?
I don't, and if Mr. Karp is willing to talk to you, I think that's fine. I would also suggest maybe since the underlying allegations.
Why would you let him talk to the judge as his lawyer and you know what he's about to say? Why would you allow it? It doesn't matter. You already did it. Here we go.
Have to do with weapons, would the court accept if he fills out an affidavit?
Well, that's going to be a component of it as well, but that's a component of the protection order.
Okay. Are you okay with answering the court's questions?
You have no choice, man.
Okay. And again, Ms. Jones, I apologize to you. I don't mean to interrupt you on some things. It's just a very narrow issue from my perspective. It's not, I understand that the housing issue is, I had a question about it, but that's not what's prohibiting me from modifying the bond. It's my specific safety concern for the church and the people who are at the church in light of the allegations and what's going on right now. And so, do you mind if I talk to Mr. Karp briefly on it?
I don't mind if Mr. Karp does not mind.
Okay. Mr. Karp, there is a mandatory protection order in this case that I issued. What the mandatory protection order states is that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing. It also states that you shall refrain from, and you cannot have contact with Cammie Fanning that would include direct or indirect communication with her. The mandatory protection order also states, are you listening, Mr. Karp, or no?
Absolutely, sir.
Okay. It also states that you cannot go to the following location. You cannot go to the Downtown Vineyard Church at 402 Grand Avenue, Grand Junction, Colorado, 81501. You cannot go to that location.
They have it blueprinted
Okay. Do you understand?
with the state.
Do you understand those terms and conditions of this?
Terms, yes.
Don't interrupt me, Mr. Karp. Let me finish. Do you understand those terms and conditions of the mandatory protection order?
Better than you.
Okay. Why would you understand them better than me when I'm the one ordering them, Mr. Karp?
You're wearing my cloak, bruh.
Okay. Are you going to follow the
Black
terms?
and
Are you going to follow the terms of this mandatory
She
protection
has a
order?
restraining order against my family. She has a restraining order and she's not allowed to be anywhere near my family.
Then why do you need to have contact
Cammy
with
can
him?
change her name and have a new alias if she wants, but she's been restrained from the entire Colorado province.
Are you going to follow this mandatory protection order and have no contact with Ms. Fanning and no
He
contact?
doesn't talk to me, yes.
Are you going to have no contact with the Downtown Vineyard Church at 402?
Unless I need to talk to the pastor.
Okay, then I'm not modifying the bond.
Mr. Jolly is my pastor, so I need to speak with my pastor.
All right, so the request to modify
I can
bond.
get a hold of him off of the church property.
The request to
Speak with the
modify
pastor
bond
off
is
property.
hereby denied. The court is going to make the finding that while there's a presumptive PR bond, and quite frankly, I've been trying to set a PR bond for the last 3 court appearances, I have no assurances whatsoever that Mr. Karp will follow the terms and conditions of the mandatory protection order in this case. I understand that it's related to his mental health. The court is trying to be sensitive on that. I've tried to refer him to the Bridges Wraparound Program for a diversion. I've tried to address these issues.
Did you try to give him his cloak back? Because you are wearing his cloak.
I want to see Mr. Karp get help. But with where things stand right now, the court doesn't have adequate assurances that the safety of the community can be protected because Mr. Karp is not going to follow this protection order, and he's essentially indicated this on multiple occasions. And so for that reason, the request to modify bond is denied. And then, ma'am, I know we talked last time, but did you wish to address the court on something else? Okay, you can go ahead and come on up. You got to come up here, though. And so if you can kind of, Ms. Walsh, would you be willing to turn our lecture? I'm sorry, thank you. I forgot to move it back after our trial the other day. Thank you so much. Go ahead and state your full name again and let me know what I need
Jamie
to.
Asherman.
Okay.
Okay, so I think everybody in this courtroom is pretty uncomfortable with the end decision here. I know I am, and I just, but I've had conversations with Victor in the past where he will respond to incentives. So I wouldn't mind if somebody entertained, what is it called, the diversion program again? What exactly is that?
It's a program where someone can sign a contract where in exchange for participating in treatment or doing certain things or staying current with medication, the DA's office would agree to potentially dismiss the case, but it doesn't work if someone's
Okay.
not willing to do
Right,
so.
and this may sound really odd, but in the past, I'm the one that encouraged him to get the public defender. And I think if he had some sort of incentive, I'm willing to, I know he would love to have this particular skateboard that I'm willing to purchase if he is willing to participate in one of these programs. And so if you want to ask him that, I'm not sure I can, but I think that he needs motivation and incentive. And it sounds silly, but I've been talking to him for the last year, and maybe that, I don't think I agree with her that Tanya, or
Why didn't the lawyers and the competency evaluators and the judge and everybody just think of that to begin with? Judge, just give him a skateboard. That'll solve everything. Ooh.
Tiana, I believe, I agree, he does not need to be behind bars. But I think if we entertain some incentives, he might respond. And I know I'm not allowed to talk to him, but maybe you could. I would be more than happy to buy him an amazing skateboard if he is willing to get the help. And then that's all I can do.
Sure.
Okay.
I mean, I appreciate that you're willing to do that. What I would note is that I think Ms. Jones heard what you just noted. Ms. Jones can maybe have a further conversation with Mr. Karp on that issue and with whether or not he'd be willing to reconsider engaging with treatment. Because if so, I'd be willing to potentially change what we're doing here today and do something different. And so maybe Ms. Jones, would you be willing to follow up with Mr. Karp about that on a later date and time?
I would be willing to talk to him later, yes.
Okay, thanks. That's all I have to say.
Thank you. I appreciate you sharing that information. And so I see that Ms. Archuleta stood up as well. Ms. Archuleta?
Your Honor, I would also like to note, as part of the rapid stabilization program, I would be happy to submit a referral for that. However, we do need the defense attorney as well as the district attorney to be agreeable to it.
Yeah, on board with it? Okay. And so, Ms. Jones, you heard that as well? And so that would be another thing that I would be willing to modify my order to facilitate. And so, again, the court is open to a lot of things in terms of treatment or stabilization. It's just with where things stand right now and your client being unwilling to participate in voluntary treatment, I just don't know what more I can do here today.
Maybe upgrade that skateboard to a Huffy bike. Maybe. I don't know. I'm just throwing out ideas. I'm just trying to be a problem solver.
I would ask for, I think the rapid stabilization program is something that was encouraged by someone in our office. So if Ms. Welsh is agreeable to it, I don't object to that.
I could also provide some additional information to Ms. Welsh if she would like that.
Ms. Welch?
I have no objection.
Okay, I'm not sure. So the rapid stabilization program, do I have to change the bond to say that it would authorize participation in that program? Or do you know off the top of your head, Ms. Archuleta?
I do not, Your Honor. I can look into that and I can file a report.
Okay.
I have not successfully had anyone go to that yet, so.
I have not either. And so that's why I don't know exactly how I have to term the bond language to facilitate it.
I will look into that and submit it.
Okay, thank you. I appreciate that. And so what I intend to do is bring this back on my next in custody docket so we can address what's going on in terms of treatment, potential diversion, what we can do for Mr. Karp. And so why don't we try to come back on Monday, June the 1st at 1:00 p.m. Does that work for you, Ms. Jones?
That works for me.
Ms. Welsh, would that potentially work for you?
It does.
And then would that potentially work for Bridges, Ms. Archuleta?
Yes, Your Honor, thank you.
Okay, let's shoot for that then and we'll go from there. Okay.
Yeah, just lost my freedom.
Okay. Mr. Karp, we'll see you back in a couple weeks, okay?
I'm an American citizen, just remember that.
Okay, I'm aware of that.
Decorated.
Thank you, Mr. Karp. Okay.
I don't even know what we just watched. I just don't. But let's move on to a stalker. That'll make us feel better.
This is Mr. Davis.
Yes, Your Honor.
All right, good afternoon, Mr. Davis. This is 26M2565. Live appearances.
Nick Schmidt on behalf of Mr. Davis, who appears with me at the podium in custody.
Good afternoon, Your Honor. Max Roth on behalf of the people. I'll let the court know that the named victim, Margaret Sanzo, appears in person in court.
Okay, and then are you wanting to address anything related to the protection order?
No.
Okay.
And Your Honor, I did file 2 different pleadings. I'm asking to address those today, please.
Okay, give me a second. All right, the court is in receipt of the people's motion to add count 2 and notice of domestic violence. The court grants that motion.
Or maybe make a record on that.
You can make a record.
Yeah. Your Honor, based on the moving papers of the people as well as the affidavit, there was no finding of domestic violence at the time of arraignment, or at the time bond was set on the 8th. There's no further indication of an active threat act or threatened act of violence in the moving papers that is different from the affidavit, or any evidence that any calls or alleged calls were for coercive control, intimidation, or retaliation. So, Your Honor, it's defense's position there is no probable cause that this is an act of domestic violence, so would be objecting.
Okay. Thank you. Give me just another second here. All right. In review of the allegations, regardless of what the court did or didn't do at the time of the original bond setting, the allegations are that there is an active protection order between Mr. Davis and Ms. Sanzo, that he has been contacting her relentlessly through the home wave system. It says that after review of the home wave calls, it was determined that Mr. Davis attempted to contact her 56 times and successfully connected calls 11 times, which then totaled 67 calls. Not only are these calls one way from Mr. Davis to Ms. Sanzo, they're uninvited by her. And the court finds that this does constitute a domestic violence factual basis, which includes, but not limited to, harassment. Therefore, pursuant to statute, I do make the finding that there is a domestic violence factual basis, and I will reaffirm my ruling and my granting of the motion to add count 2 and notice of domestic violence. Now, that takes us to our motion and application to increase bond. Give me a second. Sorry, thanks for bearing with me, gentlemen. There's just a lot to unpack here. I just wanted to do a quick review of 26 CR 661, an Adams County case. That was a February case of this year, and it involves the same named victim, Ms. Sanzo. The original charges included F4 stalking, another violation of a criminal protection order, as well as F5 stalking, causing emotional distress. Mr. Davis did plead guilty to stalking, which case did have a domestic violence factual basis. And then the other one looks like it's a traffic case, so I don't think that that is necessarily related here.
Your Honor, if I may point something out, please.
Yep.
In addition to, so, and if, would the court permit me to just make a brief record to supplement my motion?
Yes.
So the people are requesting that the court increase Mr. Davis's bond to $10,000 cash or surety and impose SRP and GPS. The people do that because we believe that Mr. Davis presents a significant risk to Ms. Sanzo. For example, and I can represent this as an officer of the court. For example, before we called the case, Mr. Davis was staring down Ms. Sanzo from across the courtroom for approximately 1 minute. And I'm saying that as an officer of the court because I observed it. I'm saying that to emphasize the risk he poses. Now, I want to point out to the court that on May 7th in the morning, we appeared in Division Q in front of Judge Martin, I think around 8:30 or 9 a.m. Mr. Davis
Judge Martin is cutie pie.
pled guilty and was sentenced in 26 CR 12 and 26 CR 661. In both of those cases, the conviction was Class 5 felony stalking. In both cases, Ms. Sanzo was the victim. In Judge Martin's sentencing, in his sentencing remarks to Mr. Davis, Judge Martin stated that compliance with the protection orders is a condition of his sentence. Now it's alleged that what seems like a few hours later, after being sentenced on those felonies, Mr. Davis returned to the jail and called Ms. Sanzo over 50 times. We have significant concerns for Ms. Sanzo's safety. We believe the court would be justified under those circumstances of setting Mr. Davis's bond at $10,000 with SRP and GPS. Thank you, Your Honor.
Thank you. And Mr. Schmidt, I'm going to have you, of course, respond. Just give me a second. All right. Thank you, Mr. Schmidt.
Yes, Your Honor, if you give me one moment. Looks like bond is currently set at $1,000 cash surety in this case. Seeing as how the change in circumstance since that bond was, set is the adding of a domestic violence tag. I would ask the court that if it is going to increase bond, it increase it to schedule, which is $2,500 cash surety, not allow or not set bond at $10,000 cash surety as it relates to Mr. Davis staring at the alleged victim in the courtroom. I was next to him. Unclear as to whether or not that is any form of threat. Don't believe it is. Looking around a courtroom is not. Obviously, I understand that the facts of his plea when these allegations came about is, I would argue, the main concern in this case. I would just ask that the court, set this bond at schedule if it does deem it appropriate to increase bond at all, but otherwise would just ask that the court keep bond set as is.
Thank you. All right. Pursuant to 16-4-109, the court does have the authority to alter bond based upon circumstances. We have a situation here where there were felony stalking allegations in both the months of January and February, resulting in pleas just, it sounds like about a week ago, to felony stalking in both of those matters. I did briefly review those factual bases. They're highly concerning to the court. Then coupled with this newest case, which was originally tagged as VP or as a violation of protection order, which the court does find constitutes a domestic violence factual basis. The allegations, as I stated earlier, were that there was almost 70 calls made from the home wave system constituting harassment. I do find that that constitutes a continuation of that stalking behavior, and that insidious harassing behavior of Miss Sanzo, and that gives me victim safety concerns, because if that is the behavior that he is undergoing and engaging in while he is incarcerated, I am very concerned about what the behavior could be if he was out on a $1,000 bond. Therefore, pursuant to 16.4.109, subsections 1 and 2, I am going to grant the motion and increase bond to $10,000, cash or surety with the conditions of supervised release program, and GPS monitoring. I am going to impose a 1 mile radius, a prohibition radius around Ms. Sanzo's residence and her place of employment, if any. All right, we need to get you into your next court date here on this matter.
20th, 8:45. That guy. She is unsafe. Unsafe. Okay, this next one is real short, but it's shocking. It's shocking, but it's short. Don't worry. It's a mother whose son has passed away. Reading her statement, but you'll see. You'll see. She's gonna bitch out the court
today because Richard should be alive and he's not. I'm here to hold the system accountable for the sequence of events that led to his death. I want the district's attorney's office and the victim's advocate to share the same blame for this tragedy. Richard had an open case here in Boulder, including a domestic violence case, where he was legally barred from coming home. During that proceeding, I explicitly told the court, the DA, and the victim's advocate that I was not afraid of him, and I begged for them to let him come back home. Instead of listening to the person directly involved, the DA dismissed me. They chose not to believe me, and the victim's advocate completely failed at her job by sharing or silencing my voice and ignoring my assessment of the situation.
Ms. Hart, I'm so sorry to interrupt you, but are these your children in the courtroom? I'm going to have you all wait outside. Thank you. Let me just tell you, Ms. Hart, it's my very firm belief that children do not have a place in the courtroom.
I don't have anywhere to put them.
Oh, no, I'm not saying you shouldn't have brought them. I'm saying I don't want them seeing their mother like this. It's completely inappropriate.
That was his mom too. And
yeah, I understand. Go ahead.
No. Because he refused to listen to me, Richard was kept away from his home. Because he was forced away from his home, he was placed in a vulnerable position that allowed his 19-year-old son to murder him. If he had been permitted to return home where he belonged, exactly as I told you he should, he would still be alive today. He'd be here to fight his Boulder cases alongside his defense team. I just want everyone to know that I feel like I was just silenced and not listened to during my court hearings or during his court hearings.
Go ahead.
That's all.
That's all? All right. I'm very sorry for your loss, ma'am. And I understand. Anything further? All right. Good luck to you.
So he committed domestic violence. They pulled him out of the home. She said, no, he's fine. I'm not scared of him. They said, no, he can't go home. So he went somewhere else, and then his son murdered him. And she's mad at the court for not letting him come home. with her kids in the room. That was just 3 seconds of crazy. And then I got one more small clip before we leave for today.
Are the PDs ready? Okay. Hi, remind me your name, sir.
Alex Hambrick, Your Honor.
Alex Hambrick. Thank you for reminding me. I know I've seen you before.
Just once.
Okay. What are you ready to
Your Honor, can I call Mr. Steibelbend?
Sure. I think he's appearing from Adams County Jail
He
number 9.
is.
Okay.
I don't know if they're switched over to whatever computer they wanted to use or not, but.
All right. The court calls 26M2307, Mr. Steibelband. Are you still there, sir? Adams County Jail number 9. Okay, they're saying I am here. I can't hear him.
Can you hear me?
Yes, I just can't see you.
Okay. Hey,
All right.
Can I start my video, please?
Okay. All right. Good afternoon, sir. And we have Mr. Hambrick from the Public Defender's Office, Mr. Apigi from the District Attorney's Office. What are your requests, Mr. Hambrick?
Your Honor, we would be requesting to set this into a county court division, just to further discuss with the district attorney and then some things that have been said during that conversation.
I'm very
Maybe some
sorry.
competency
I disagree.
concerns.
I disagree. Excuse me, sir. As my public defender, if I may, Your Honor, I would like the maximum penalty possible. I am guilty as condemned.
All right, so we're not going to get to that part today, but the next court date, you can enter a plea of not guilty or guilty if
I
that's
would
what you
like
choose.
you, Your Honor, to enter summary judgment for me.
Okay.
Do you
I'm not able to
understand?
do that. I do.
You
I'm
understand?
not able to do it. Okay, please don't yell at me.
Do you understand? I am done with this. This is a circus. This is an absurd court. I am done. Enter a maximum penalty for me. I do not deserve to be here for many reasons, and you know that.
All right. I've heard from Mr. Strivelbrand. I understand his concerns. We need to set this for a dispositional hearing in the county court division. That will be set on June 12th at 8:45 in person in Division 5. Is there anything further, Mr. Apigi?
Nothing from the people.
Okay.
Your Honor, I believe there has to be an order for offense-specific evaluation in this case.
All right. As I told Mr. Strivelbrand, we're not at the point where an entry of a plea takes place, and so he'll hopefully talk with his attorney about the next steps and what he would like to do.
Thank you.
This is set on June 12th at 8:45 a.m. in Division 5 in person. Good luck to you, Mr. Strivelbrand.
I don't understand if it's something in the water, if it's a full moon. I don't understand, but people were crazy today. I just don't get it. Calm down. Relax. You're overreacting. Y'all. Thank you so much for coming out today, guys. I really, really appreciate it. I'll see some of you tomorrow morning in about 6 hours. So go rest, relax, enjoy your night, and I'll see you again real soon. Thank you so much. Bye, guys. Yes, Micah, we agree on the oatmeal. Absolutely.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace, come join the fun. It's a welcoming place, and so